Hi, I'm James Vann with Vann Attorneys, and welcome to our webinar today. We're so thankful that you have chosen to participate with us. We hope this will be helpful to you. We're going to be talking about confessions of judgments and promissory notes and how that can help you in your business. But a little bit of just homework beforehand, and a lot of you know this, if you want to submit a question, you actually can use the control panel on the GoToWebinar portion of your screen, and you can submit it that way, or you can send us an email at webinar@vannattorneys.com. We will try to answer those live while we're doing this. So again, we're thankful that you are here today. We've got actually a really good crowd. One more piece of homework for you. Mark your calendars for February 18th at 3 o'clock. That's when our next webinar will be, and we are working on that topic right now. So February 18th of this year, and we look forward to talking together. So let's get started and looking at what we're going to be talking about today. So we're going to be looking at promissory notes and confessions of judgment when there's a debt, right? So I know a lot of you have used these types of tools before, and so hopefully this is something that's educational for you, but hopefully helpful for you in your business. And we're going to be looking at how do you protect your company when you're owed the money. What options are available? How do you use promissory notes in North Carolina, confessions of judgments as well, a deed of trust, and then how about collateral? How would you ask for collateral, and what would that look like? So this first slide here is really an idea that we got from one of our listeners, and so thankful for that. So how do you handle this with a good customer, right? Customer owes you a lot of money, and they're a good customer, right? You don't want to offend them, right? So it's a business transaction. Several of you knew our family business that we had years ago, not law practice, but other stuff. So I remember hearing my mom say to her customers, this is not personal, this is business, right? So it's a business transaction. So I think about that very often. This is not personal, this is a business transaction that we need to just document and figure out how to get that customer back on track to paying you for what is already owed. And you also want to make sales calls for the future stuff, right? Sometimes you may want to cut them off totally and not have them as a customer anymore. That's always your choice. But if you want to keep them as a customer, but you just got to clean up this past due amount, you certainly can do that. You want to keep the great relationship with the customer. And it does not have to be a relationship ending transaction. Again, that bridge may have already been burned, and you'll know that. Customer probably will know that as well. But hopefully it's not, right? We want to continue to sell good people, right? So let's look at some promissory note issues. So in North Carolina, it is a contract between the lender and the borrower. It's regarding payment of money that is due, right? It's usually this money already due. You can't have a promissory note for loans that will be made, but usually it's money that's already due. And the promissory note can be secured or unsecured. That is, secured in some kind of property. Hopefully it's real property, and the reason I say that is this: real property is hard to hide it. It's also hard to move it, right? And generally the value stays the same. Hopefully it decreases and not or increases and not decreases in value. We actually have a client who took a piece of property in a fairly rural area. I think they were a second or third tier lien holder on the property. That is, they at least had a first and a second mortgage on it already. And so when they took the deed of trust, they didn't have a lot of equity in it. The first and second eventually got paid off, and so our client is now first. But unfortunately, the economics of this town has made this property not as valuable as it was 6 or 7 years ago when they were owed all this money. But the good news is they still have some kind of asset that they can put their hands on if they need to. So, some people say, well, I don't want to get into all that. Well, then that may be what you don't want to do. But if the customer has some kind of collateral that they can use, I would certainly encourage you to do that, right? So let's look at promissory notes in North Carolina. They need to include the following. It needs to have a date, and generally at the very top, and there's actually a standard form for a promissory note, but all kinds of provisions can get changed. Just because you see a promissory note does not mean it's a standard form. But look at the top. It should have a date for the promissory note. It needs to identify the parties fully. It does not need to just say, Jim Vann, right? It needs to have James R. Vann or James Robertson Vann to fully designate. And also, if I owed you money, who you are, right? So the note clearly says, I owe your company or you individually, however it may be. You need to identify the parties fully, and also list the address of each party fully. Also, where the payment is to be made. And it also needs to address the principal amount that's due, and also include the amount of interest and how is it to be calculated. So sometimes we see, notes that are drafted and the interest calculation is really confusing. So think through that and maybe have someone else read it just to make sure that it makes sense. About the repayment information, that needs to be in there. How is it to be paid? When is it to be paid? Where is it to be paid to? Is it to be paid in check? Is it due on the 1st and late on the 5th? You get to make all those decisions. When is the note? When's the final payment due? Right? Is it a 4-year note? Monthly payments, and calculate all that out. Right? You need to include a provision for reasonable attorney's fees in case the customer does not pay. And also, what are the terms of default? So we've got an issue now where one of our clients drafted their own promissory note, and unfortunately, it was not. They didn't use a standard form. It was not a very well written promissory note. It will work, and we have filed suit on it. But there's some things that are missing, right? So what is a default? Is non-payment a default? Probably, but you need to spell that out. And then the borrower actually needs to sign it. The other thing I would encourage you, and I know a lot of you already know this, if we've helped you with your credit application or other similar documents, the word seal, S-E-A-L, a lot of times it's in parentheses on the signature line of a document. So for example, if you borrowed money recently, if you've gone to your bank, or if you look at the promissory note, you may see the word seal, S-E-A-L, in parentheses. And in North Carolina, what that does is it changes the statute of limitations. Normally for a contract in North Carolina, most of the time, it's a 3-year statute of limitations. So you have 3 years to go after the customer if they don't pay, right? There's a breach of the agreement. The word seal actually gives you 10 years of statute of limitations. So we encourage you to put the word seal, if you're doing your own prom note, put the word seal on the signature line, right beside it, S-E-A-L, and put the word in parentheses. Really would encourage you to do that. So hopefully that's helpful to you. But before we get to confessions of judgment, we got a survey question that we want to ask you. So this should pop up on your screen. And the survey question is having to do, the poll question is having to do with how often do you use promissory notes. So you should see that popping up. I don't see it, but hopefully you see it. We'll give you a few seconds to answer that. And so it's the answers are sometimes, often, never. We'll give you about 10 more seconds, and then we will close that out, and then I'll give you the results, or I guess we'll reveal those results to you. So how many people use a promissory note with your customer? So I know some of you do, right? So 71% of you said sometimes, 14% say often, and 14% never. So 71% sometimes. And I'm glad that you do. So let me encourage, let me think about this just for a moment. Let's just say, for example, I'll back up this last slide, but so when you have a credit application, or you have a customer that you have a contract with them, right? It is a promise to pay. That's already a promise to pay. And the promissory note is just another promise to pay. And there's nothing wrong with it. You know, and a lot of times I've told many of you that are on the phone, that are on this webinar, if you've got a customer, if you're thinking about doing a prom note, I say do a confession. We're going to talk about confessions next, because a promissory note, again, is just another promise to pay. So they've already not been able to fulfill the first one, so I want them to put their money where their mouth is, right, and do a confession of judgment. So, and they're both really difficult to get around. So I'll tell you two stories. One is a client of mine many years ago, and this is one of those cases that still haunts me. had he bought a business and he signed a promissory note for that. And part of the collateral was the accounts that he bought. Unfortunately, what he bought, or what he thought he bought, was not what he actually bought, because the quality of it was really bad. And he made the payments, I don't remember how long the payment term was, he made the payment for a while. And then he finally got to the point, he's like, I'm not paying this guy any more money. It's just a bunch of mess that I bought, and that he lied to me. So we were trying to put pressure on the seller, but unfortunately, my client had signed a promissory note, and once you're locked in on a promissory note, it's pretty tough to get out of it. The seller hired a lawyer, and we did our best that we could do, even though we had this prom note that says he's going to pay this amount and this way, and here's the collateral. Well, we lost because there were no defenses to it, unfortunately. That's why it still haunts me, because I couldn't change the situation for him. And it was pretty devastating to his business. So they are enforceable. The other thing I want to tell you is, if you're consider a promissory note, I would say consider the confession of judgment. If you get your client to sign it, your customer to sign it. So what a confession is, you don't have to have a lawsuit already, right? It's agreed to by your customer or by the debtor. It's in writing, it's signed by the debtor, it's notarized, and it includes a payment schedule, right? So, for example, let's say the customer says, look, I can pay, $3,000 a month on the 15th of each month, and I'll do that for the next, 2 years or 3 years. So instead of having them sign a promissory note, ask them to do a confession of judgment. And generally what happens is, most of the time, our clients will hold these without filing them with the court. And so what the advantage of that is it gives the customer an opportunity to actually make the payment like they've said they will, right? And if they make those payments and there's no problem, then you hand the confession of judgment back to them once they've paid it, right? You've got all your money, you've got your interest, and then you give them confession of judgment back, then they can shred it and get rid of it, right? But if they don't pay, then you take the confession, you can go to the courthouse, file it, you automatically have a judgment against your customer for the judgment amount, less any payments that have been made. You have to give them a credit for the payments that have been made, of course. But then you don't have to file suit. You don't have to go through a lawsuit. You already have the judgment. That's why it's called a confession of judgment. Again, it's a great tool. We've been talking about this with clients for years. It's a really great tool. So it generally includes a payment schedule. And it's, again, as I said earlier, it's not filed with the court unless the debtor fails to make the payment timely. There are details to it. For example, the amount of the payment, when it's to be paid, where it's to be paid, the date of the payment, and so forth. We just use this tool in a mediation where the customer owed our client money. We said, look, you got to do a confession that we're going to hold it. We're not going to file it. And if they make the payments, then we'll turn around and give it back to them once they're done. So the great thing is we don't have to fight in court anymore about this, which is really nice. And it gets the client what they want, and that is the payment, right? Again, too, it's agreed to by the debtor. It results in a judgment if the agreement is breached. It's cost effective. It also adds an attorney's fees provision in there. I would say do that, right, in case then you can go after them for that if you need to. So that's a plus. And it's just, again, it's not another promise to pay. So the promissory note, let's just say, for example, that one of your customers, they sign the prom note, but then they don't pay. You've got to then turn around and sue them again. Well, not again, but you got to sue them to enforce that prom note if you want to, right? If you want the money, if you want to enforce it, you got to file suit. Well, a confession, you don't have to. You just go clock it in, which is really nice. So before we get into the security part, we've got one more survey question for you. It's going to pop up, and it talks about how have you used a confession of judgment with your customers. And so again, the options are usually, I think, sometimes often, and never. So we'll give you a few seconds to enter that. And I know many of y'all, we've helped you with those, with a confession of judgment. So we'll give you about another 5 seconds, and then we'll give you the results. Okay, let's see what it says. The results are 27% says sometimes, 20 say often, and then 53 say never. So again, 27 is sometimes, 20 often, 53 never. So I really want to encourage you to think about this. Let me also mention this. Can you draft your own confession of judgment? Yes, you can. Should you? No, you shouldn't. And I'll tell you why. It's not that expensive, number one. If you've already negotiated all the terms, just have us do it. We had a client not too long ago draft their own confession. And unfortunately, they changed just enough that it was almost unenforceable. I say almost unenforceable. We really had some question whether or not the court was going to allow it to be enforced. Thankfully, they did. Another situation, multiple times where the client, our client has drafted something with a confession to have their customer sign it, and they've changed so much or wasn't signed correctly or there was some question about it, and it's just no good. You can't enforce it with a court. And the reason I say, I mean, it doesn't cost you that much to have us draft it and make sure it gets signed, and then we can stay out of it, right? We're not trying to do a job. It's not job security for us. It's a service to help our clients. And the same thing with promissory notes. I know a lot of y'all draft your own promissory notes, and that's okay. I would encourage, prom notes are not quite as damning if you don't get it right, but if you start with a great form with a prom note, you probably have a good chance of it working. If your form is not so great, then I would argue that you may not have a great end product. I would not say that on confession, because it is a pleading that you file with the court. There's a big difference to that. So I would highly encourage you not to draft it, but you certainly can if you want to. I've got a client who she worked for a big supplier. Great client, love them so much. She's unfortunately retired. Fortunately for her, I just miss dealing with her, working with her. And she took one of our forms and had a lot of clients sign a confession. This is a number of years ago. And a handful of them didn't pay, so she sent them to us to enforce them. And I told her, I looked at them, I'm like, oh my gosh. I was like, where did you get this form? She said, well, I took it from one of yours and I just changed some stuff. And I'm like, yeah, the stuff you changed made it unenforceable. So please don't do that. I want this to be beneficial to you. That's why we say that. So hopefully that's helpful. I will tell you another quick story. And as long as you get most of it right, you're probably pretty good at least on the promissory note side. So years ago, I grew up in Roxborough. Some of you know that because you're on this webinar and are from there. There's a guy who, his family was very wealthy. He was out of town, and he wanted to buy a piece of equipment, and he didn't take his checkbook, and he never carried cash. And this is really before credit cards were a big thing. And he was getting ready to buy this piece of equipment, and he's like, oh man, I left my checkbook at home. And they were like, well, how are you gonna pay for this? He's like, hey, give me that. That was an envelope. He said, give me that envelope. It was a blank envelope. He said, give me the envelope. And he wrote on there basically an IOU or promissory note. And he said, here's this. Take it to the bank, the national bank that they use, First Union at the time. And he said, and they'll cash it for you. And the guy's like, you're crazy. Well, he put everything he needed to on that envelope for it to be negotiable. And that's a legal term, what's called negotiable. It's like a check, right? Or a promissory note is a negotiable instrument. And he wrote everything he needed to on it, had signed it. And so the guy took it to First Union, a long time ago, obviously, cashed it. So I'm not encouraging that, but that can work. So how do you secure the debt for payment, right? What can you use? We've talked about it before, using real property so much better than a piece of equipment or a piece of like a vehicle maybe. But securing the debt with real property, it's voluntarily provided by the debtor. Usually there's a deed of trust against the property that you want to use. The deed of trust is filed with the real property records in the county where that property is located. So again, there is a little bit more to it, but at the same time, if you've got a fairly decent debt and you want to get some security so that you make sure you got something else in your pocket in case that guy or that person doesn't pay, it puts you in a much better spot. So what are some of the pitfalls of using a piece of property for debt? Well, the debtor may not want to do that, right? Especially if it's their house. They may, oh, I don't want to give you security on my house. And also restricts the free transfer of that property by the customer. So let's say, for example, and we've had this a lot of times where the debtor owes you money and we want to get a deed of trust on it. They go, but yeah, I want to sell that in a couple of years. Well, then if you sell it, then you need to make sure we get paid, or that our our client gets paid. That's a great thing for us. The customer may not like it, but at the same time, if the customer doesn't have a lot of options, it's a great way to secure the debt. We had this situation, it was right before the COVID thing hit. We had a person or a company who owed a lot of money to our client, and we were narrowing them down in a corner, and they didn't have the money. They didn't have the cash flow either. So we're like, okay, you got to give us some security in property. And really the only thing they had was a couple pieces of commercial property for their business that had other mortgages on it already, and then their house. And so we got a second deed of trust on the commercial piece of the property and a second on their house. I would much rather have a second deed of trust with a chance of getting something than having nothing. And then guess what happened? That person filed bankruptcy. So what happens to the security? In a lot of respects, and again, depends on how it happens, you're going to be protected in bankruptcy. And the great news is you are called a secured creditor. That's a great spot. Most of us a lot of times fall in the unsecured creditor status when we get into bankruptcy, and that's not really where you want to be. So securing the debt with the real property, some of the benefits, it obviously gives you collateral, assuming again that there's equity in the property. The value doesn't change rapidly, again, depending upon where you live. And then also the debtor cannot sell the property without getting you paid. And I can't tell you the number of times when I've heard customers say, I'm selling this big property, and when I sell that, we're going to get you paid. And you just hope that it happens, right? My heart drops at times when I'm like, that may not happen. But you just want to make sure, try to put yourself in that position if you can. So what is a credit line deed of trust? And we've mentioned this over the years to some of you. We've actually helped some of y'all put this into place, and it can be a really beneficial relationship. But the credit line deed of trust, it actually provides for security of an open account. So a customer comes into you and says, look, I want to buy, I'm going to be buying products from you, materials from you, supplies from you, or whatever the relationship is. And, I'm going to be buying, a lot from you over the year. And you look and you go, it's just, unfortunately, we don't have as much, the relationship is not strong enough, or the customer is not financially strong enough to carry all that debt. So what happens is this: the customer gives you a credit line deed of trust. It is a deed of trust against a piece of real property or pieces of real property. And the credit line, is basically an open line of credit. It can be $0 or up to whatever amount that you decide is their credit worthiness warrants. It's voluntarily given by the customer. It provides collateral for you, which is a good thing. Gives flexibility in the revolving line of credit for the debtor's varying balance, depending on how much they're buying and selling, to give you back. And it also limits the debtor in making further advances against the real property. So, for example, if you get let's say they have a piece of property and you get a deed of trust on it for the credit line, right? So in that sense, they can't sell it, which is really good for you because you're secure at that point. And if the customer gives another deed of trust against that property, you're certainly ahead of them. Or if there are other judgment debtors that sue them and get a judgment, they can't sell the property without you getting paid, assuming again that there's equity in that piece of property. It's actually a deed of trust that's against the real property. It's filed again with the county where the real property records are located, which is the Register of Deeds office. And it's a great way to protect future purchases by the debtor. So we used to do this a lot especially when there were other tract builders around, not the nationals, because they won't do it, but others where they're building multiple houses. There's a lot of benefit. Now again, there's a stack of paper that they need to sign early on to do this, but it's a great way to protect you if they're doing this, right? If you've got a customer that's doing it. And we've got the whole package. We can help you with it if it comes available, if you need that. So if you do, just call us. We'll be glad to talk you through it and see what it looks like. What about accepting vehicles for collateral? Well, I'm gonna tell you, there's some pitfalls. We'll talk about it, but it's again voluntarily given by the customer, and it gives you some degree of security. So what's the tough part? Well, the tough part is you can't find it sometimes, right? So you don't know where that is. And the other thing I would say is this: a lot of times people will say, "Hey, look, I've got the title, right? The customer gave me the title. I've got it right here. They've got it in your drawer or in your file cabinet or lockbox or whatever." But they've never, on the back of it, had the company or the creditor listed as the lien holder of the vehicle. Please don't do that. And I'll tell you why. The customer can go to the DMV and get a duplicate title. So they've lost that owner, whatever. They get a duplicate title, then they could sell it. They could give somebody else a lien on it. They can do anything they want to. And all you guys is literally a piece of paper. That's it. So if you decide to take a vehicle as collateral, on the back, it lists the lien creditors. You list yourself on there, you send it to DMV. DMV then registers you as a lien holder, and then they will probably send you the title back. And then on there, it lists the company, your company, as a lien holder. So they can't sell the vehicle unless they pay off the lien. So please don't just hold on to the title. I can't tell you the times that's happened to some of our clients, and they're like, "Oh my gosh, you can't, please don't do that," because that doesn't help you at all. And plus, some of the other negatives are, again, the value drops, right? If it's wrecked, then you don't have anything, right? And you just don't want that to happen. So we talk about its questionable value. The value changes can change quite rapidly. The collateral can be moved. I've got a client right now, we're trying to find a vehicle and we can't find it. They have no idea. We've looked and looked and looked, can't find it, which is not fun. The benefits, again, almost everybody owns a vehicle. It's easy to obtain the collateral when you complete the lien and title information and file it with the state. And again, the customer can't sell it without it. So what about if you do take real property as collateral? What does the foreclosure look like? I know some of y'all have been in this situation. You're selling a real property to satisfy the debt. It's controlled by the promissory note and the deed of trust, and then North Carolina state law. So the prom note really does matter, and the deed of trust really does matter. So you got to look at those things because those really control, and of course state law controls it as well. You've got to follow the procedures to protect the customer, but also protect you. But it's something that we do a lot to help our clients. You've got to give them written notice, of course. You have to have a pending lawsuit to foreclose. You got to give public notice, and all of those have some time frames within which you got to get all that done. So what are some best practices that we can tell or suggest to y'all that you might want to think about? Document your agreement for repayment, whatever that looks like. Make sure that you have a really good, well-written document that the customer has agreed to and signed off on, right? Use whatever tools you've got. Promissory notes are not bad, right? I love confessions of judgment because it gets you closer to where you really want to be if you have to enforce it. Keep the customer on track for the repayment as well. Sometimes you might have to nudge them, right? Hey, the payment was due on the 1st and it's the 5th, don't see the payment. We just had this issue in a confession of judgment issue, and you get that gut feel, right, about how they're going to pay. And I don't believe this person is going to do what they say they're going to do. I still don't believe it. And so I told them, I said, here's the deal. The money has to be wired to our trust account for our client by the 1st of the month, or we have to have the check by the 1st of the month. If it's on the 2nd, we're clocking in the confession of judgment because I just know how this person is. I've dealt with them in this case long enough to know. I'm like, I don't want to put up with that. When is it due? So sometimes you have to keep them on track. Y'all know how to do that because you do a lot of it and do it well, right? Again, I'm going to encourage you. This is business. This is not personal. I'm not trying to be ugly. Not trying to be rude. It's just business, right? We need to get this taken care of. And if it's a good enough business relationship, you want to keep it, right? You don't want to push that customer somewhere else. There are those that I know that sometimes we want to push somewhere else, and that's something you get to do. And then the other thing I would encourage you is enjoy each moment, right? Even when it's up to here and you can't get it all done in a day, enjoy the moment, right? It's worth it. So we hope if you have questions, let us know. Feel free to reach out to us. And hopefully this is helpful to you. Thank you so much for those who have sent us emails or suggestions regarding topics. We really do hope that you will reach out to us if you have questions. We can help you. Thank you so much, and we look forward to hopefully connecting with you on February 18th. Thank you so much.